there's been a violation of my client's human rights, okay, and constitutional rights, and the court is empowered, even at the magisterial level, to stay proceedings for an abuse of its process. And an abuse of process can result from a misconduct by the executive, okay, or the executive arms, whoever represent the state. A misconduct would have occurred in that situation by detaining my client in excess of 48 hours. Now, what I also explained, and it seems to be a trend among persons, among the police, that they can hold persons for 48 hours. That is not the law. 48 hours is the outer limit. Persons should be brought to the court within 24 hours, and that is in keeping with their constitutional rights as well. So while we cannot raise the constitutional issue here, constitutional violations as well as basic breaches of human rights, the court can entertain that area. Okay, and that is the submission that we would have made in relation to Mr. King's matter.
Can you give me the timeline of when your client was taken into custody and when he was brought to the court, and why you are alleging that this violation occurred?
Yes, so based on my instructions, my client was picked up on the Friday, March the 25th at 9:13 a.m. He was kept in custody until then. This is the first time that he's out of custody, having been brought to the court. Now, if we are to count hour for hour, that is way in excess, because 48 hours, if that is the outermost limit, which in any event, like I indicated, it is the exception, not the rule. He should have been out by Sunday morning, okay? But this is where we're at now. So it is way in excess, almost close to 72 hours that my client has been in police custody.
You were telling the court that based on the criminal code, I think it is, that
Criminal Procedure Code.
the criminal procedure code, that when somebody is brought into custody, certain things should happen. Can you explain this to the benefit of the viewers?
Yes, please. As soon as a person is brought into police custody, the officer in charge of the station, he is responsible for coming and seeing or finding out why this person is at the station. So it's not a matter the police just bring them and leave them there on the bench, like we see happen time and time again. And the lawyers have to come and ask, okay, who can tell me about my client? It should really be the officer in charge as opposed to the investigating officer, but we'll take either who can give the information, who is to inquire why that person is there. And based on the information that is received, that supervisor or the superior in charge of the station would determine whether this person should be charged or not. Charged or sent home.
And if that doesn't happen, if the person is in fact charged, let's say on a weekend, can the police legally keep them in custody until Monday and then bring them to court?
That is why subsection 2 of the legislation would have intimated that they can be released on a bond. Once it's not a serious offense, they can be released on a bond to appear before the magistrate on the first hearing date or on the date that is stated in the magistrate's file.
And
on the bond, sorry.
And is it your argument that your client could have been, based on this law, released on a bond and he did not have to stay in custody?
Yes. Because the police would have known that they are unable to keep him. They would not have been able to bring him to the court within 24 and at most 48 hours. This is a flagrant violation of his basic human rights. This is a violation of his constitutional rights to freedom. So it must not be allowed to continue.
What decision did the court make?
Well, we are to reduce this information in writing, so it will be more detailed, supported by further case law, which we already have, because it's not the first time that we've successfully made such an application. So we'll be more than prepared to provide the court. And on the return date, the court will make a decision. On the 25th of April, the court would make its decision.
And of course, the prosecution would respond to your submission.
Yes, they have to respond by the 11th. I believe that was the court's order, the 11th of April.
Your client pleaded not guilty to the charges. Did he tell you about his experience during his detention and what it was like?
Yes, I would have visited my client on a few occasions while he was in police custody, and I would have gotten the information from his family and from him as well too. Yes, I wouldn't want to divulge it too much, but we know it's a dire situation. It is not pleasing, it's not pleasant.
All right, thank you very much for your time.
Thank you.